Thank you for tuning in to TalkWad.com, the world's fastest growing internet radio network. Please check out all the other great shows on www.talkwad.com.
What if your customers are trying to find your business online, but instead of finding you, they find your competitors? Now, more than ever, it's time to make sure you have the right SEO to make your business stand out online. Welcome to Go Mind Your Business with Terri Bork, presented by Extreme Marketing Concepts, putting your business in front of the hungry herd of buyers who are looking for you right now. Extreme Marketing Concepts, helping you drive more traffic, dominate the market, and crush your competition. And now, here's Terri.
Hello, everybody. Welcome to another edition of Go Mind Your Business. My name is Terri Bork with Extreme Marketing Concepts. My very special guest today is Noel White. She is a state attorney in Dunedin. Welcome to our program today, Noel.
Well, Terri, thank you so much for having me today.
Oh, it's my pleasure to have you on the show. So glad to have you. And, life today changes so drastically, and I have so many questions for you. So I'm really looking forward to learning more about estate law.
Well, wonderful. And I really help to educate you and your audience so they understand some of the laws and some of the things they can do to be proactive.
Perfect. Before I get started, let me share with our audience a little bit more about you and your company.
Okay.
Perfect. So Noel White is an attorney whose practice is located in Dunedin, Florida, and Noel helps reduce stress for her clients by assisting them with their estate planning and providing services in areas of probate, trust administration, small business matters, and litigation on contested probate and consumer matters. Noel graduated from Mercer University with a BBA in finance, and she graduated Stetson University College of Law and has been practicing since 1989. Noel also serves as an arbitrator for Motor Vehicle Lemon Law Division and on the Clearwater YMCA Advisory Board. Noel is married to her husband, Jack White, for 23 years, and she's the mom of Natalie and James. So, Noel, what made you want to become a lawyer?
Well, Terri, it's actually kind of an interesting story because I was not one of these people who grew up thinking, oh, I want to be a lawyer. But after college, I decided that I wanted to further my education, and I wanted to go into an area where it was not going to be the same thing every day. So I decided, well, I thought law school was a wonderful option, so I took the standard test and applied and got into Stetson College of Law, and then had my legal education. And what's really neat about law school that a lot of people don't realize is law school, you have a general education. You don't really specialize in an area. It's not until you get out of school and get that first job and through your work that you start going into a different field and narrowing your law practice.
I got that. Okay. So you settled on estate law.
Yes.
What exactly is estate law?
Well, I actually call it estate planning.
Sorry, okay.
And what that is that is a way that people can get their affairs in order. And by that I mean making sure that they have a will or a trust. Those are documents where you're actually saying what you want to happen to your stuff, your property after you've died. And it is a way of making sure that those things are actually distributed the way you want them to. Now, there's another aspect of estate planning, and those are through advance directives. Advance directives are documents that are good while you're still alive, but you're putting people in charge of your health care decisions and your finances with the idea that those people will step in the event you're unable to do it for yourself.
Okay, I got that. So is that really what an estate is?
Well, your estate, technically under the law, is your property. And your property can consist of real estate, bank accounts, certificates of deposit, investment accounts, anything that you have an interest. It's your personal property in your car. And so through your estate planning, you're directing how you want those items to go. It, when you die, I have to share something with you. One thing that I hear often is when people say, if something happens to me, and it's not a matter of if, it's a matter of when. Is it going to be sooner or later? But inevitably, it happens to all of us.
I got that. Yeah. I know none of us want to think that there is like an end point, right? All right, perfect. Now we keep talking also, before we get deeper involved, we talk about property. Are children part of your estate plan?
Well, they're of course they're not property.
Oh, okay.
However, a lot of times what parents of young children will do in their will or their trust is put some direction as to who they want their children to live with in the event of their death. Now, a lot of times though, there's people who might be divorced. And for instance, the child, if you have like a minor child, and you may want your sister to take care of the child in the event of your death. Well, of course, the natural father is going to have priority. Now, that's making some assumptions, and ultimately it's up for the court, but provided there's a good parent and it's in the best interest of the child. But you may not want your ex husband to manage the money for the child.
Right.
So, through your estate planning documents, you can appoint another family member or trusted individual to manage those funds for your children until they reach the age you specify in the document. Now, I want to emphasize the fact that you get to state what the age is. If you do not do any type of plan in your documents, now, and a child inherits money and it's over a certain amount under the law, it would go into a guardianship, and the court will oversee that guardianship. And at the point when the child reaches 18, then the guardianship is terminated and the child would receive any funds that are left for that child. Now, I don't know about you, Terri, but I don't know many 18-year-olds that you want to give a bunch of money to. And
No. My son is 18, and while I love him dearly, I do not know that he would be financially responsible at 18 to know what to do with it.
so, Terri, most parents will pick an older age that that child would actually get the assets. And usually we're talking money at
Hmm.
this point, that there's money that's been set aside for that child to be used for their health, education, and welfare. And then at the age you specify, then what money would be left after the trustee used those monies to pay for those expenses, then the child would gain control of.
Perfect. Okay, that makes it so much clearer for me. That's good to know that we have control, even after we're gone, somewhat of, things that we leave to financially that we leave to our children.
Absolutely, and who's going to manage those and who's going to control those,
Perfect.
and a lot of times too, it can be a balancing act because with having a trust set up for a child, there are expenses involved with the administration of that trust every year. So you really need to keep that in mind and how much money we're actually talking about as to how long you want that trust in force. Because I've had some people who say, well, I don't want them to have any money until they're 40. And you just have to look at what are you actually talking about, and in the management of those funds, and if that's going to be in the best interest of the client.
Okay, great. I totally got that. We are speaking with Noel White. She is an estate attorney in Dunedin, and you can visit her website at www.dunedenattorney.com. It has some wonderful information on there to answer some of your questions. Or you can give her office a call, and she's happy to speak with you. You can reach her at 727-735-0645. So, Noel, why do I need a plan?
Well, by having a plan, you are directing what will happen to your estate or your property after your death. Now, I get a lot of questions, and people will say, well, what happens if I die without a will? And one of the myths out there is the state of Florida is going to get all my assets.
Mm-hmm.
That's not true. What will happen is the Florida statute will dictate how that property is distributed. And it is in our Florida statutes, and it's called the intestacy laws. And intestacy means essentially dying without a will. And so that those statutes will say this is what happens to that property. Now, I need, though, to make clear that when those intestacy laws will only apply to those assets in the dead person's name alone. And so if, for example, John Smith has a bank account and John Smith's name is only on that account, then the intestacy laws will apply. I have to make the differentiation because one of the techniques that a lot of people will use is by either having joint accounts or they may have beneficiary designations on accounts. And the documents with those financial institutions will actually dictate how that property is distributed after a person dies. So if for example, John Smith had a joint account with his wife, Mary Smith, most likely those bank documents are going to say the survivor gets those funds. So it would not matter what the will or trust says. The way the asset is titled, or if there's a beneficiary designation on the account, is going to dictate how that money is distributed upon a person's death.
Okay. Oh, that's really important to understand.
Well, and let me go a little bit further. Until last year, when people would get divorced, if, for example, you had a life insurance policy and you never took your ex-husband off that life insurance policy, that ex-husband would get that money.
Mm-hmm.
Most people I know don't want their exes to get that type of money.
No, it's really for the children at that point in time. So you would need to change your beneficiary designations.
I still recommend that you change it. However, fortunately, our Florida legislature put a law in place. Now, this only applies to people dying after July 1st of 2012.
Okay.
I believe that's the date.
Okay.
Which found that certain assets, and it's specified in the statute, I don't know all the details off the top of my head, but certain assets such as life insurance, that in the event of a divorce, then that spouse is considered to have predeceased.
Okay.
But it's still a really good idea that if you get divorced, update your beneficiary designations.
Right. Now, but going along with that, like when I got divorced, we decided that we would maintain the life insurance policy that we had, and leave the children with the guardianship on there until, whatever, because we wanted to be able to give our children a future. And that was my divorce. I know that may not be true of all divorces, but, we made that agreement that we would take those proceeds from that, maintain payments, and do that. So that would still be okay.
Absolutely. And I'm glad you brought that up, Terri, because for people where there may be a marital settlement agreement, by no means do you want to do anything contrary to what your marital settlement agreement states. You need to fulfill those obligations. I'm just talking generally about some situations where people may have neglected to take an ex-spouse off of an account.
Got it. Okay, perfect. No, thank you for clarifying. That helps me a lot because I'm like, well, we have this set up. I don't want the children not to receive it. And my children are older now, so they would be at certain ages where, different things could come into play, but that policy is still active and it's not going away.
And what I recommend is after a person's children have gained majority, it may be worth looking at that marital settlement agreement, and then with your estate planning attorney, along with having an attorney that's familiar with your divorce settlement, it might be your divorce attorney, just making sure what are we able to do and what are we able to update. Because for a lot of people, what I recommend to my clients, once they have done their documents, to get those documents out every 3 to 5 years and review them and make sure they say what it is that you want them to say,
Hmm.
because life changes.
Yeah.
And the person you may have designated as wanting to be the guardian for your children may not be the right person anymore. So you want to keep all of that information up to date.
Oh, that's brilliant. I know that when my children were little, we elected godparents for our children um, we went through a baptism process and named godparents, and we were under the assumption that those people would be the people that would take care of our children in case something were to happen to us. So we are not tied. Well, my children are grown now, so it wouldn't apply, but people don't have to, if they have a falling out with a friend, or a friend deceases, or you've moved, or whatever the situation is, you might want somebody else to handle your children.
Absolutely. So you want to be sure that you keep that updated.
Perfect. Okay, great. um, are there typical estate planning documents that you advise people to put together?
Well, I always have to give you the every the it depends answer.
Okay.
And I say, oh, people will ask me questions. I say, oh, I've got to give you the lawyer answer. It
Sure.
depends, because every situation is different.
Hmm.
So what I'm about to say is just really going to be general information
Hmm.
that may or may not apply to a certain situation. And so your audience out there, if they do have any questions about their specific situation, they really need to sit down with their estate planning attorney to make sure that the right thing is done for their particular situation. Because that is one thing with estate planning. It can be simple and it can be very complex, depending upon the person's assets and what their intentions are and what they want to be sure to accomplish through their estate planning documents.
Okay, I got that.
So, what I'm going to say is really what I see often, and I like to call it my simple plan.
Okay.
And oftentimes you're talking about a husband and wife. They own a home. Um, they may be what we traditionally call like middle class. They both work. They have some money in the bank. They have some life insurance, and they may have some retirement accounts.
Hmm.
And so, for a lot of people, they may be looking at uh, having a will done. And what the will is essentially stating, I think everyone knows what the will is, but
Hmm.
because we see it on TV, the last will and testament.
Right.
But the will is stating, this is how I want my property to go, and this is who I want to put in charge of that estate
Okay.
plan in the event of my death.
Hmm.
Now, the other documents are those advanced directives I made reference to before. And those consist of a living will, and there was a lot of publicity about living wills with the Terri Schiavo case.
Yes.
But the living will is a written document stating that if you have an end stage condition, terminal condition, or you're in a persistent vegetative state, and your doctor and another treating physician, I want to specify that it takes two doctors, are of the medical opinion that you're not going to recover, you're saying, do not keep me artificially alive. I'm going to just digress a minute, just a little bit on that living will, because the living will is not the same as a do not resuscitate order.
Okay.
And a do not resuscitate order is a document that is done between the patient and their doctor. And I won't
Okay.
get into a lot of specifics,
Sure.
but that I want to just make sure people know that a living will is not the same as a do not resuscitate order.
Okay.
The next document is called a healthcare surrogate form. And
Okay.
a healthcare surrogate is where you most often name a person and then an alternate person to make healthcare decisions if you're not able to do so for yourself. And then the last document is a durable power of attorney form. That is an extremely powerful document, and that is where you appoint a person, and you may or may not appoint an alternate to handle your finances.
Okay, great. Now, are all of these things done when you create your will? And can they change over time?
Well, most times when people will see an attorney, the attorney will give them options, but most people want to do a complete plan. Because not only do you want to have that roadmap as to what happens to yourself when you die, but more importantly, who's going to be put in charge while you're alive, but you're unable to handle things while you're still alive. Now, other document that a lot of people will do, and you hear a lot of people talk about revocable living trusts. And what a revocable living trust is, it's almost like a contract with yourself where you are setting something up while you're still alive. A lot of people will do revocable living trust because it is a means of avoiding probate. And what probate is the court process of getting assets out of a dead person's name into the name of the named beneficiaries. I don't want to go into a lot of detail about revocable living trusts, but the real important thing is that revocable living trusts can be a great vehicle if they are used properly and people fund it. I've had a number of clients come into my office and they have a nice 20 to 30 page revocable trust, and I look at them and say, so tell me, what assets do you have in your trust? Because when you set up a trust, you need to retitle your assets. Instead of having your bank account Terri Bork, you would have Terri Bork, trustee of the Terri Bork Revocable Trust.
Right.
There's different ways of naming it, but I'm just using a common example. And if people haven't done that, they're not accomplishing what they want in avoiding probate.
Mm-hmm. Oh, wow. That's really um, important then to make sure that you have everything scheduled out the proper way.
That absolutely, and following your attorney's instructions.
Got it. Okay, great. When we come back, we're going to learn how wills distribute property, which I'm really excited to learn more about. You're listening to Go Mind Your Business. If you're ready to have a press conference for your business, give us a call at 813-863-1452, and we're happy to talk to you and your business about what you do and how you help others. We'll be right back after this brief commercial interruption. Okay, maybe in just a minute. Let's see here. Where's our bell?
Oh,
Here it
it's
comes.
right
Okay, we'll be
here.
right back after this commercial interruption. Okay. And we are back to Go Mind Your Business. My name is Terri Bork, and my very wonderful guest today is Noel White, an estate attorney from Dunedin. If you have questions, you can visit their website at www.dunedinattorney.com, or you can give their office a call directly at 727-735-0645. Well, Noel, as I promised before the break, we were going to learn how a will is used to distribute property. So can you share that with us a little bit?
Sure, Terry. What I'm going to describe is a will. I like to call it the roadmap. And after a person has died, the wherever the original wherever the original will is located, or whoever has possession of it needs to file it with the clerk of court in the county where the person lived. A lot Unlike other states in up north, Florida wills are not filed with the clerk of court until after a person has actually died. So once the will is filed with the clerk, there's paperwork that the attorney prepares for the named person in the will as the personal representative to sign. The personal representative is the administrator, or another term that's often used is executor. and they're the person who's actually put in charge by the court to handle the matters of the estate. So what happens is that they petition the court to have the will admitted into probate. And assuming that there are no challenges to the will and all the formalities with the execution of the will were met, the will be admitted to probate. And once the probate process starts, there's certain procedures that have to be complied with for the estate administration in order before the assets are actually distributed to the beneficiaries. Let me go in a little bit more detail. What happens in Florida, there's actually two types of probate administration in Florida. There's called a formal administration, where you have your personal representative appointed, and you have a summary administration. And a summary administration is available to those estates where there are no creditors, or if there are creditors, they are going to be paid in full, and the value of the assets are $75,000 or less. Now, in that calculation of the $75,000, there's certain exempt assets that aren't counted, which might be homestead property or exempt property. You can ask me more details on that if we have time, but those do not get counted towards that value.
Mm-hmm.
Now, more commonly, there is the formal administration, and that's the process where you actually do have your personal representative appointed. And the personal representative will receive what are then called letters of administration, and that is their authority to act. That's what you're able to bring to the bank in order to close out bank accounts, open up an estate account. You're able to get your tax ID number for the estate, and there are certain procedures. For example, a notice to creditors is published, where creditors are given 3 months in order to file claims in the estate to make sure that whatever the decedent owed, decedent owed, that is paid from the assets of the estate.
Okay, perfect. All right. So, are there ways that people can dispose of their property without going through probate?
Absolutely, Terry. And I mentioned these a little bit earlier on. Most of the common ways that I see is through making beneficiary designations on bank accounts, life insurance policies, that type of thing. When you make your beneficiary designations, the financial company is going to pay those persons that are listed. Now, I do want to, though, caution everybody to make sure that when you do beneficiary designations, that you read the fine print in the form.
Mm-hmm.
Let me give you an example of the importance of that. Let's say you've got John Smith again, and John Smith is a widower and he has 3 children. He wants to avoid probate, and he has an investment account. And he puts those 3 children on as beneficiaries on that investment account. Now, he wants to make sure that if any of his 3 children died before him, that 1/3 going to that child would go to his grandchildren. That may or may not happen depending upon the small print in that beneficiary designation form. The beneficiary designation form may very well have language in it that would provide that those assets would just go to the surviving beneficiaries, instead of going on to that 1/3 going to the grandchildren. So it's very important that you familiarize yourself with what those documents actually say, and that they're actually kept up to date. So that's one of the more common ways people can avoid probate. The other one was what I had referenced earlier, and that's through the revocable living trust.
Okay, I got it. A phrase that I've heard in the past, Noel, is called a testamentary trust. What is that?
Good question, Terry. A testamentary trust is often in a last will and testament.
Okay.
I mentioned about the revocable living trust, and that's the trust that you set up now. A testamentary trust, most of the time, not always, because every situation can be different, but most of the time you're talking about setting up a trust for minor children. And it's a conditional trust. So if, for example, I've got two children who are minors, and I know at 18 I don't want them getting any money. So I have it set up that if either of my children are under the age of 25, that their money actually will be put into a trust for them and used for their benefit until they reach age 25. But that is actually in my will when that's a testamentary trust.
Okay, perfect. So is it better, and I might be confusing them now, is it better to do a trust or is it better to do a will?
And I'm going to give you that lawyer answer,
Okay,
Terry.
that's okay.
It depends.
Okay.
There are a lot of people who they've come to my office and they want a living trust, and I will go ahead and do living trust. But I'm going to tell you, my experience has been that living trusts are not necessarily for everyone. Because if it's evident that a person is not going to really understand how it works, and by that, the importance of transferring their assets into the trust in order to avoid probate, then it's really not necessarily a good fit because they're not accomplishing what they want. What will end up happening is you have this wonderful trust you have set up, but if you've never put anything in the trust, guess what? You have a probate, and then you also, on top of that, have a trust administration.
Right. Okay. And that makes sense to me. I remember my parents talking, and they were like, "Yeah, you got to put the house in the trust, and we leave maybe we leave one item out, but other items in because they're easier to dispose of certain things. But like, other things are you don't want outside the trust." And I remember them saying it's very complicated, and you need to work with somebody who absolutely knows what they're doing, so it can be done properly.
Well, and one nice other thing about with trust that can make them a great vehicle is usually within your trust you have, well, what happens is that if it's my trust, I'm going to be the trustee of my trust. But there's provisions in that trust that state that if I've become incapacitated, then my successor trustee is going to be able to step in. And that oftentimes that can be where a trust can be beneficial because you've got that successor trustee who can go ahead and step in the event of your incapacitation, and then they're substituted in on the paperwork with the financial institutions. It's already in the trust. You're just then substituted in as the new trustee.
Got it. Okay. You know, durable power of attorneys. I've heard that so much. They talk about it on TV all the time. What does it mean? What is that?
Okay, a power of attorney is where you give authority to someone to act for you. The difference between a power of attorney and a durable power of attorney is a durable power of attorney is still in effect even if you become incapacitated. There's special language within the document that says if I'm no longer capable or I'm incapacitated, this person is still authorized to act for me. And I've got to stress, Terri, that it's so very important for people, if you've got a trusted individual in your family, to have given them durable power of attorney, because it is a way of avoiding guardianship proceedings. Because what happens if a person becomes incapacitated, let's say they have dementia or Alzheimer's, and they're no longer capable of paying their bills and making those type of decisions. If you have not done a durable power of attorney, then your family is going to be forced into a guardianship proceeding. And I had a call from a client probably about 3 weeks ago, and her father, she ended up getting guardianship over her father, and she got a bill from the attorney for $18,000.
Oh my goodness. So it's good to take care of these things when you're of right mind and you can make the right decisions for yourself and just have them there for when they're necessary, if they become necessary.
And that's correct, Terri. But I do want to stress that if you do ever give power of attorney, that it is someone that you absolutely trust, because it is a very powerful document. And so, for example, you give someone your durable power of attorney, they are in essence you. They can go to the bank account. They can take the money out of the bank.
Well, do they have to be, are they able to do that anytime after you sign that over to them, or is it only when you become a certain way and declared incompetent or unable to take care of yourself?
Well, as the law is now,
Uh-huh.
it is as soon as you sign that document.
Oh, so that's kind of scary.
That it Florida used to have a provision called a springing power of attorney that was conditioned on an incapacitation,
Mhm.
but that went away in 2011. In 2011, our durable power of attorney statute was completely redone and newly adopted, and so now the document, as soon as you sign it, it is effective.
Mhm. Okay. Wow. Okay. So just, know who you're assigning. So if you want your child who's of the right age, I suppose, or your spouse or something, then those would be good, or your folks.
Absolutely, Terry. And let me bring up one important thing that your statement just brought to mind.
Okay.
A lot of people think that because they're married and that they have joint accounts, that they don't need a power of attorney. I will tell you, if anyone needs durable powers of attorney, it's spouses for each other, because there are indeed certain assets where you may have your spouse named as a beneficiary. And I'll give you an example. Let's say an IRA. You may have your spouse as a beneficiary, but guess what? If you're incapacitated, that spouse cannot deal with the company without having authority to do so. The the well spouse might be named as the beneficiary, but guess what? You're not dead. You're
Hmm.
incapacitated.
Right.
And if the well spouse does not have durable power of attorney, they do not have authority, and the company's not going to talk to them.
Wow. Okay. Now, that's really important to know. My next question, I guess, that goes along with it. What if something happens to the person that you elect to be your durable power of attorney? Maybe it's your husband and you get divorced. Maybe it's the child, but as time goes by, that child might not have been the right choice, and you want the other child to be the one that handles the situation because maybe that child lives closer to you and the other one moved away, or whatever the situation is, because every family is unique. Um, can you change these things?
Absolutely. Any of these documents that we've been talking about, as long as you are competent,
Mhm.
you are able to go ahead and change those documents.
And then who makes those decisions as far as if you're competent?
Well, oftentimes when a client comes into my office, I'm going to be able to judge by their responses and able to have a conversation if that whether or not they're competent. However, there are some situations where it may be questionable, at which point then an attorney may very well uh, advise they want a doctor's evaluation and have a letter provided to them as to the person's competency.
Perfect. Yeah. Because, TV, they have all these scenarios, so not that, somebody wouldn't do something right for their family, but you want to make sure
Right.
you protect yourself and your family.
And let me just kind of go along that same vein. Is let's say you have someone who has been diagnosed with Alzheimer's or dementia. They may have actually lucid moments,
Hmm.
and it can be through those lucid moments that they still, for legal purposes, have the competency to be able to do these documents.
Okay, perfect. Yep. Well, that is wonderful. We spent a lot of time talking about so many things are so important to people, and making sure they have themselves together for, when it happens, that they're protected. Is there anything maybe that we did not talk about that you want to make sure we cover?
Well, one document that I referenced to is with the healthcare surrogate
Yes.
forms, is making your medical designations, and on all these type of documents with the powers of attorney, making health cares, you can actually name alternate people in place. So in that scenario on your power of attorney, if you had done the documents years ago and you named your spouse and your spouse is now deceased, you may have an alternate person who'd be able to step in.
Okay, great. When I look to hire an estate attorney, Noel, what should I be looking for?
You really want to look at having a person that you have a good relationship with. that you feel that you have a rapport with and that you're comfortable with working. There's a lot of good estate planning attorneys out there, and you may want to interview attorneys. Oftentimes people will ask their loved ones and friends who they've used, and a lot of my business comes from word of mouth and referrals from clients.
Perfect. Okay. Well, Noel, you were incredibly helpful today. And I know, listeners, if you have any questions about your estate, Noel is more than happy to help assist you with any of those questions. You can find her website by going to www.dunedenattorney.com, or you can call their office directly at 727-735-0645. Noel, thank you so much for joining us today. It was so great to have you.
Well, Terry, thank you so much for inviting me. I really enjoyed it.
Yeah, oh, it was great. And you brought so much clarity to this kind of gray kind of area for me. So thank you so much again. And again, you can reach her at 727-735-0645. You're listening to Go Mind Your Business down here at the Talkwad studio. If you're looking to have a press conference regarding your business, give us a call at 813-863-1452. Thanks so much for joining us today, and I look forward to seeing you next time. But until then, go mind your business. Have a great day.
Thank you for listening to Go Mind Your Business with Terri Bork, presented by Extreme Marketing Concepts. If you want to drive more traffic, dominate the market, and crush your competition, find out how by visiting our website, www.extrememarketingconcepts.com. And join Terri next time for another episode of Go Mind Your Business.